5 people filing 5 identical adjustment of status applications on the exact same day could get 5 completely different outcomes right now because of numbers almost nobody's actually talking about. Not the headline, the math underneath it. On September 18th, the public charge rule changes, and everyone's covered the basics. What almost nobody's covered is what the government's own numbers say is actually about to happen, and why one specific historical statistic might be the most important thing in this entire story. Let's start with the number that should genuinely stop you. Over a 5-year stretch that included the entire 2019 version of this rule, public charge denials made up just 0.087% of all adjustment of status applicants. Less than 1 in 1,000. And even among that tiny fraction, the ones that actually stuck weren't usually about benefits at all. They were almost always about a missing or insufficient Form 1-864, the affidavit of support. That's the historical baseline. That's what strict public charge enforcement actually looked like in practice last time this happened. Here's why that number matters so much right now, and why I don't think it's going to hold this time. The 2026 version of this rule removes the guardrails that existed even in 2019. It doesn't bring back the old rulebook. It deletes the rulebook and hands officers a pen instead. Quick pause here, because if you're weighing whether to file before or after September 18th, the next few numbers are exactly what you need. Go ahead and hit subscribe and turn on notifications because we're going to keep tracking this as real enforcement data starts coming in. Now let's talk about the money, because DHS put actual figures on this themselves. The department's own estimate projects $13 billion less flowing to immigrant families every single year and $111 billion less over the next decade. Not because benefits got cut, but because people are expected to voluntarily disenroll or simply never apply, out of fear. That's not a side effect. Multiple immigration attorneys reviewing the rule believe that fear is doing more of the actual work here than the enforcement itself. And here's the number that makes that fear genuinely dangerous rather than just cautious. The Kaiser Family Foundation projects that somewhere between 1.4 and 4.1 million people currently enrolled in Medicaid and CHIP could drop coverage because of this rule, and buried inside that range is something worth sitting with directly. An estimated 56,000 to 1.7 million of those people are U.S. citizen children. Kids who were born here, who are citizens by birth, whose coverage was never actually at risk under this rule to begin with, losing health care anyway, because a parent panicked without knowing the actual rule. Let's clear up exactly why that panic is misplaced, because the rule is explicit on this specific point. DHS states it will generally not consider benefits received by an immigrant's family members as the immigrant's own benefit. Your U.S. citizen child's Medicaid, CHIP, or SNAP is legally the child's benefit, not yours. There is a real nuance buried underneath that, though, worth understanding precisely. Officers can still weigh the broader financial picture. If your household needs those benefits because income falls below a certain threshold, that income level itself becomes a factor in your overall public charge assessment, even though the benefit receipt technically isn't attributed to you directly. That's a genuinely different thing than my child's benefits count against me. And getting that distinction right could be the difference between an unnecessary decision and a genuinely informed one. Here's a number that quietly changes how much protection your own paperwork actually offers you. Under the old framework, a properly completed Form 1-864 was treated as presumptively positive, meaning officers generally accepted it as sufficient proof of financial support once submitted correctly. That presumption is gone. An officer can now look at a sponsor demonstrating 6 figures of income and still weigh it against other factors in the file. The form is still legally required and still fatal to your case if it's missing or insufficient. What's changed is that submitting it correctly no longer automatically closes the question the way it used to. There's one more number worth understanding if you're anywhere near the public charge bond process. Bonds posted on or after September 18th get breached by receipt of any means-tested public benefit at all, a meaningfully harsher standard than what applied before. Bonds posted before that date keep the older, narrower rule. If a bond is even a possibility in your case, That filing date isn't just a preference, it's a completely different legal standard attached to your money. So here's what these numbers actually mean if you're trying to make a real decision right now, not a theoretical one. If you're eligible to file today, talk to an attorney about the filing date specifically, because that date, not your interview date, not your priority date, is what determines which set of rules applies to your entire case. Don't disenroll your U.S. citizen children from benefits out of fear. The numbers show that's very likely an unnecessary sacrifice based on a misunderstanding of how the rule actually works. And the KFF projection exists specifically because so many families are making that exact mistake right now. Keep detailed records of any benefit you've personally received, which program, which dates, why, and for how long. Because under this rule, the specific circumstances matter far more than simply which category of benefit it technically was. And when you fill out your I-485, be precise about excluding benefit amounts from your reported household income where instructed, because DHS has specifically warned that including them incorrectly can trigger a misrepresentation finding under a completely different, more serious provision of immigration law than public charge itself. Here's the honest, bigger picture these numbers actually paint. Historically, this specific ground of inadmissibility affected a tiny sliver of applicants, well under 1%, and mostly for a paperwork problem, not benefit use itself. But this version of the rule removed the very framework that kept that number so low, replaced it with broad officer discretion, and the government's own financial projections suggest the real impact won't come primarily from denials at all. It'll come from millions of people, many of them the U.S. citizen children of applicants, quietly walking away from benefits they were legally entitled to the entire time, based on fear rather than fact. Before you go, make sure you've hit subscribe and turned on notifications, because we're going to keep tracking exactly how this plays out once real enforcement data starts coming in after September 18th. If this video helped you separate the actual numbers from the panic spreading around this rule, share it with someone who might be making a decision about their own case or their kid's coverage based on fear instead of facts. Thanks so much for watching. Stay informed, stay prepared, and take care.